Hi, this is John Tompkins, the defender here in Indianapolis, Indiana, with another question of the day. Today I'm going to address something that comes up frequently, which is the decision to either go to a jury trial or waive jury and do a bench trial. Why would you do either one of those? First and foremost, the number one question that you have to ask when you're trying to decide if you want to do a bench trial versus a jury trial is, do I have a judge in my case who will actually say not guilty every once in a while? Because if you're in a court where a judge does not acquit people in jury trials on a regular basis, you really don't want to consider a bench trial no matter what. Because a bench trial is where the judge decides whether you're guilty or innocent, instead of 6 or 12 people on a jury deciding whether you're guilty or innocent. So question number one, do I have a judge who's going to come into this with an open mind and I have a decent chance of convincing the judge that I'm not guilty? If your attorney thinks the answer to that is no, do not waive jury. Second, you have to realize that you only have a choice for a bench or jury trial in misdemeanor cases if you request a jury very quickly, early on in the proceeding. Most misdemeanors, you're presumed to only have a bench trial, and you actually have the affirmative requirement to request a jury trial. So you may have opted for a bench trial without even knowing it in certain misdemeanors. As soon as you speak to an attorney about a case, find out what your deadline for requesting a jury is, if there is one, and get that request in. You can always change your mind later and waive it and go back to a bench trial, but if you don't request it in certain misdemeanors, you won't have the choice in the future. Now, back to bench or jury. So once you've decided you've got a judge that, if you have a good case, will say not guilty, then you have to decide, what kind of defense do I have? That's a big factor in whether you want to waive jury or not, and it sometimes is the reason that you do want to waive jury. For instance, if you have a technical legal defense, there's a rule of law that says that the form you filled out is not subject to the fraud statute. Something like that is something that a judge will have a much easier time understanding and a much easier time finding you not guilty on, whereas a jury might look at that as merely a technical defense. You knew what you were doing, and now your lawyer's trying to talk all fancy and get you out of it. So in a technical legal defense, you want to seriously consider waiving jury just so you get an informed lawyer assessing whether that legal defense is valid or not. So there is mistake of fact defense, for instance. Mistake of fact defense is one of those defenses where you say, yeah, I did a few things, but I was mistaken. You might get a bunch of jurors who, well, I would never make that mistake, or how could somebody make that mistake? Whereas a judge knows what the mistake of fact defense really means and knows how to apply the law to it. So where you might spend the whole day just trying to explain the legal jargon around what that kind of defense really means, and the jury still might not get it, a judge would know right away, and you could go straight to the facts that support your defense. Now, the other reason that you might want to seriously consider waiving jury and doing a bench trial is the officer that you have in your case. Most jurors are going to look sort of at all police in the same status. They're all having a positive reputation because the police force has a positive reputation. Now, in some cities they don't, but in most cities they do, and most jurors are going to see all police as equal because they all wear the same uniform. That, of course, is not true. Police are like any organization, and there are some good ones and some bad ones. There are some good defense attorneys, there are some bad defense attorneys. Regardless, a judge who is in court every day and seeing these officers come and go on a regular basis knows them as individuals. So he knows if you have an officer who tends to exaggerate, that officer tends to exaggerate. And he will weigh the credibility and how much weight he'll give that officer's testimony as that officer as an individual deserves, as opposed to just a blanket, well, I respect police officers, so I'm going to believe what that officer says. So that's another reason you might want to waive. If those reasons don't exist, you probably want to stick with a jury. Jurors you can trust. You need a good attorney who does a lot of jury trials, has the ability to communicate well to jurors. But that's not a jury versus bench question. That's getting a good lawyer. And hopefully, if you ever need one in Indianapolis, you'll come talk to the defender, John Tompkins. That's my answer for the day to your question of the day. Bench or jury, it's up to you. Think about it seriously. It's an important decision. Talk to your attorney about it. They'll have some good advice for you along the lines of what I've said today.